Hello everyone, welcome to Bajirao IAS Academy. Yesterday we have discussed about some important topics in Indian polity, particularly the significant aspects of the Indian Constitution. And apart from that, we have also understood the amendment procedure of the Indian Constitution, how it could be amended, and the basic structure doctrine as well. Right, so now we have some more topics which are very important, particularly one topic, that is secularism, because secularism is also one of the very interesting and very important topic, and it is always a debatable topic, particularly in the Indian context. Right, so because of majoritarian tendencies, people believe that secularism is threatened or secularism is in a danger, right, particularly because of the majoritarian politics that have been taking place in India. And in this context we will understand and basic structure doctrine that was given by the Supreme Court in Keshwanand Bharati judgment. Now Supreme Court in SR Bommai judgment has also held that secularism is also part of the basic structure doctrine. So that essentially means that Parliament can actually amend any part of the Constitution, but it should not destroy the secular character of the Indian Constitution. So this is what the basic structure doctrine actually means when it comes to secularism. Now we'll understand what is the meaning of secularism. What is exact meaning of secularism? Now secularism is an ideology. It is a Western ideology because this ideology has originated in the West, right, particularly with respect to the separation of church and the state. Right, so there was a Renaissance movement in the West. As part of that particular movement, as part of the reformation of the relations between the state and the church, secularism as an ideology, so that was originated in the West. Right, so this is being viewed as an ideology, and that ideology particularly emphasizes on the separation between the religion and the state. So this is the exact definition of the secularism. So secularism essentially means that the separation of the religion and the state is what is known as the secularism. However, one thing that we need to understand here is that neutrality of the state. So state is neutral. State would not intervene in the religious activities with respect to the religious beliefs also. So state would be a neutral. So here there are two things that we have to understand, is that Western secularism is very often described as a negative secularism. Western secularism is negative secularism, but on the other hand, Indian secularism is a positive secularism. So these two things that you have to understand. This is positive secularism. So positive secularism is Indian secularism, and negative secularism is the Western secularism that most of the countries follow in Europe. Now, what does exactly the negative secularism and positive secularism mean? Now, when I say negative secularism, it is the complete separation of state and religion. Complete separation of state and religion. So that essentially means state will not intervene in any activity of the religion. So there will be a complete separation of state and religion, and that is the Western secularism, or it is also called as negative secularism. But on the other hand, what exactly is a positive secularism? Now, positive secularism essentially means that state view every religion equally. State view every religion equally, still state intervene in the religious matters. Right, so state intervene in the religious matter in the benefit of certain socially and economically disadvantaged groups. For example, triple talaq is a religious practice. Triple talaq is a practice which is considered a disadvantage for the woman. Now state intervenes. state intervenes and triple talaq has been declared as illegal practice. So this is for the protection of the rights of women, ensure that there is a gender equality, right? So ensure that there is a gender equality. So that is what is called as a triple that is what is called as the positive secularism, which is followed in India. Right, so I hope you have understood what exactly is a positive secularism, what exactly is the negative secularism. For example, I would give you another example which which tells you what is a positive secularism. For example, in Hinduism, there was a Devadasi system that was existing. Devadasi system that was existing in India, particularly in Hinduism, right? So Devadasi system essentially means attaching young girls to the temples as a property of the god, right? So Devadasi system is considered as a derogatory practice to the dignity of woman. So therefore, the state would intervene and state would prohibit this Devadasi system to protect the dignity of the woman. But on the other hand, West, there is a complete separation of state and religion. State will not intervene in the religious matters. So that is actual difference between the positive secularism and the negative secularism that is followed in the West. However, so when we talk about secularism in India, it has two broad meanings. One is separation of religion from the state. So religion would be separated from the state. Okay, so second is equal respect to all religions by the state, and this is what is followed in India. So in India, all religions are equally treated, equally respected by the state. So that is what is called as Sarmadharma Sambhava. Okay, so Sarva Dharma Sambhavam. So this is what is given by Mahatma Gandhi or held by Mahatma Gandhi as well. And we will understand there are certain constitutional provisions. So these constitutional provisions, particularly with respect to secularism in India. So what are those constitutional provisions? We'll try to understand those constitutional provisions as well, because so if you look at those constitutional provisions, they reflect the secular character and the secular nature of the Indian Constitution. For example, Article 14 of the Indian Constitution, right? So Article 14 of the Indian Constitution, right to equality before law and equal protection of laws. So everyone, irrespective of religion. So therefore, don't you think that this also reflects the secular character of the Indian Constitution? Right? So everyone would be treated equal in the eyes of the law. So that is a rule of law. So therefore, this also reflects the secular character of the Indian Constitution. And similarly, Article 15 of the Indian Constitution. So Article 15 of the Indian Constitution talks about prohibition of the discrimination on the grounds of religion, race, caste, sex, place of birth. So therefore, there will be no discrimination by the state based on these specific characteristics. So therefore, Article 15 of the Indian Constitution also reflects the secular nature or the secular character of the Indian Constitution. And similarly, Article 21 as well. And Article 21 talks about right to liberty, right to life and liberty. So this also reflects the secular nature of the Indian Constitution. Similarly, we have a right to religion, and this right to religion, particularly from Article 25 to Article 28, so they also reflect the secular nature of the Indian Constitution, because Article 25 talks about the right to religious conscience of the individuals, right? So they have the freedom to practice the religion of their choice, and that is what Article 25 of the Indian Constitution talks about, right? So they can follow whatever religion, they have the freedom to follow whatever religion of their choice. So it is Article 25, and that also reflects, because here state is not intervening, state is not informing you that you should follow that particular religion. You're getting it? So therefore it is also a secular, it also reflects a secular character of the Indian Constitution. And apart from that, there is another article, that is article 26 of the Indian Constitution. So this 26 of the Indian Constitution also says that the right or the freedom to establish and maintain religious institutions, or institutions with a religious character. So therefore this also reflects the secular character. And article 27, the freedom not to pay taxes to the state. So state will not impose taxes on these religious institutions. And article 28 talks about any religious institution can impart religious education as well. So these are the secular features of the Indian Constitution. Now apart from that, what are the other secular features of the Indian Constitution? Now article 29 as well, the right of minorities to establish and the right of minorities to protect, conserve their culture. Article 30 also talks about the right of minorities to establish and administer educational institutions of their choice. And similarly, there are other constitutional provisions also. As of now, we have just discussed the secular character of the fundamental rights, the secular provisions which are mentioned in the fundamental rights. And in fact, the directive principles of state policy also talked about the secular character or the secular features and even fundamental rights as well. So fundamental duties as well. Now when we talk about the fundamental duties, article 51A. So article 51A of part 4A specifically talks about the fundamental rights. Now one of the fundamental right is that it obliges all citizens to promote harmony and the spirit of common brotherhood, and also value and preserve the rich heritage of our composite culture. So this is what article 51A of the fundamental duties has been talking about. And similarly, the 42nd Constitutional Amendment Act that was made in the year 1976. So this 42nd Constitutional Amendment Act has added secular feature, has added the ideal of secularism to the Indian preamble. Okay, so Indian Constitution's preamble, secular term was added through the 42nd Constitutional Amendment Act. So this also makes India a fully secular state, right? So this makes India a fully secular state. Now, apart from the constitution, judiciary has also helped shape secularism in India. So we'll understand how judiciary has actually helped shape secularism in India. So there are two important judgments, so through which we could understand how judiciary has helped shape secularism, the secular character of the Indian Constitution. The first very important judgment is the Keshwanand Bharati versus State of Kerala judgment 1973. And this is very important judgment because we have understood that throughout 1960s and 1970s, the basic structure doctrine has been evolving. However, it has been ultimately culminated through the Keshwanand Bharati versus State of Kerala case 1973. So in this case, the Supreme Court has held that Parliament can amend any part of the Indian Constitution, but it cannot alter or destroy the basic structure doctrine or the basic structure of the Indian Constitution. There are certain provisions which forms part of the basic structure, and Parliament cannot alter the basic structure doctrine, and this is what the Supreme Court has said in the Keshwanand Bharati versus State of Kerala case. Now, in this case, Supreme Court has held that secularism is part of the basic structure doctrine. And similarly, there is also another case called S.R. Bommai versus Union of India case. right? So SR Bommai case of 1994, and in this particular case also the Supreme Court has further elaborated on the meaning of secularism. So Supreme Court has given a broad definition of secularism, what constitutes a secularism, how the parliament cannot alter the secular character of the Indian constitution, right? So in this SR Bommai judgment, the court has held that secularism means equal treatment of all religions. Equal treatment of all religions. So this is what the Supreme Court has said in SR Bommai judgment, equal treatment of all religions. Now we'll briefly understand what is the difference between Indian secularism and Western secularism. So one thing that we should understand here first is that, as I have already mentioned, that Indian secularism is a positive secularism, and on the other hand Western secularism is a negative secularism, right? So Western secularism is a negative secularism and Indian secularism is a positive secularism. Now in this context, let's understand the differences between Western secularism and the Indian secularism. So Western concept of secularism connotes a complete separation between religion and the state, right? So this is also known as the negative secularism, the complete separation between the state and religion. And positive secularism, so Indian constitution talked about the positive concept of secularism, that means giving equal respect to all religions or equal treatment of all religions. So that is what the Indian constitution talks about. And in fact, in Western secularism, the state cannot give financial support to the educational institutions. Imagine that there are some educational institutions which are solely managed, maintained or run by the religious organizations or religious communities. So in Western countries, state cannot give financial support or financial aid to the educational institutions which could be run by these religious communities, nor state can hinder the activities of religious communities as long as they are within the broad limits set by the law of the land, right? So this is the Western concept of secularism. But on the other hand, Indian secularism is different because Indian constitution has permitted the partial financial support to religious schools. Okay, so for example, imagine that there are some schools which are run by, organized by, maintained by the religious communities. So Indian constitution has permitted state to provide a partial financial assistance to those schools, as well as financing religious buildings and also infrastructure by the state as well. So this is the difference between the positive secularism and the negative secularism. And even in Western countries, it has no place for the idea of state supported religious reform, because state will not intervene in the religious reform activities of the religion. So there will be complete separation. Now you could understand this is completely different from what is happening in India, because in India state would intervene, right? So state would intervene for the purpose of religious reform. So as we have understood about triple talaq, we have understood about the Devadasi system in Hinduism. But in Western countries, Western secularism, there is no place for the idea of a state supported religious reform, and state will not go for the religious reform also. But on the other hand, if you look at the Indian secularism, so Indian secularism is actually considered as compatible with the idea of a state supported religious reform. And in fact, state would play a proactive role when it comes to reforms in some religions. And that is what is called as equal respect or equal treatment of all the religions. So there are some examples being given. For example, Constitution has banned untouchability under Article 17 of the Indian Constitution. And in fact, the government has also enacted several laws which aimed at abolishing the child marriage as well. So the minimum age for a girl child to get married is 18 years. However, in Western secularism or in Western countries, individual rights are at the forefront. So that is what is known as individualism, right? So they give priority and primacy to the individual rights over the community rights or the collective rights. But on the other hand, Indian secularism deals not only with the religious freedom. So there should be a religious freedom for the individuals, and that is what is talked about in Article 25 to Article 28 of the Indian Constitution, that talks about freedom of religion, right to freedom of religion. Okay, so therefore in Indian secularism, so it deals not only with the religious freedom of individuals, but it also deals with the religious freedom of the minority communities as well. However, Indian secularism has been criticized on certain grounds. So we'll understand what are those grounds why Indian secularism has been criticized by the scholars, right? So firstly, it is said that Indian secularism is anti-religion. So anti-religion in the sense that, state has been intervening in the religious matters. State intervention in the religious matters. So because of this particular reason, it is considered as anti-religious. But on the other hand, in West, state will not intervene in religion or religious matters, or state will not support the religious reforms also in the Western secularism. And because of that particular reason, Indian secularism is called as anti-religious. And secondly, secularism is a Western concept, right? So it is not an Indian concept, it is a Western concept. Its origin traced back to the West, right? So particularly the present day Europe. So therefore, the Western idea of secularism will not suit to the Indian context, because India is a multi-diverse, multi-religious society. So that is what the critics have been arguing, that secularism is a Western origin and that would not suit to the Indian context. So therefore, secularism has no meaning in India. And third is that it leads to the appeasement of the minorities, or minority appeasement in the politics. So minority appeasement in the politics. So this is also another major criticism of the Indian secularism. And in fact, so it also interferes with the religious matters as well, because state has been actively intervening in the religious matters for whatever matter it is, for whatever reason it is, particularly if it is for the religious reform, then also the Indian Constitution has provided for the interference of the state in the religious matters. So therefore, this is also another major criticism of secularism in India. And in fact, religion or secularism is very often used for vote bank politics in India. Vote bank politics in India. So Western scholars' criticism is that India lacks the democratic culture. So we have democracy, but we lacked the democratic culture, and because of that particular reason, various political parties using religion, various political parties also using secularism as a tool to mobilize voters, and that will not good for any healthy or functional democracy. And in fact, it also further encourages vote bank politics by creating or polarizing the minorities and majorities. So that also leads to the vote bank politics. And in fact, Indian secularism is an impossible dream, and that is what because it is an impossible dream in the sense that we have a multi-diverse, multicultural society, and because of that reason, the Western idea of secularism will not suit to the Indian context, and that's why it's impossible that India could become a secular state. So these are some criticism about the India's secularism, right? So apart from that, we'll understand there are some factors which are threatening India's secular fabric. So it is important for us to understand what are those factors which are threatening India's secular fabric, and we will also understand some challenges that secularism has been facing. Firstly, political interference in a religion or religious matters. So this is the one factor which could threaten India's secular fabric, which could threaten the harmony that has been existing among various communities in India, because we very often see that religion is being used for mobilizing voters. Religion is being viewed as a vote bank politics, as a tool for vote bank politics. And in fact, religion is also actively used for the polarization, or to create polarization in between different communities, right? And in fact, candidates for elections are selected based on the religious considerations, and vote are also cast based on the religious sentiments as well. Now imagine a place or a constituency which is a Muslim majority constituency or a Hindu majority constituency. Now in those constituency, the candidate would be most likely a candidate who belongs to the majority religious community. So because that is what is called as India lacked the democratic culture. This is the criticism of the Western scholars, right? So religion also plays a very important role in the elections, and that's why some political parties intentionally or deliberately marginalize, or I would say give very less number of seats for certain religious communities, so that the winning chances would be very high for that particular political party, and they could also form the government. And secondly, there is a non-separation of religion from politics. So this is also another criticism, and that could potentially threaten the secular fabric of the Indian constitution, right? So that could threaten the secular fabric of the Indian constitution, right? For example, there are events that took place in the past as well. For example, demolition of Babri Masjid, anti-Sikh riots that took place in 1984, Mumbai riots in 1992, 1993, and even Godhra riots of 2002. So there is a non-separation of religion and politics that you could see in all those instances as well. And apart from that, there is a deliberate or intentional exclusion of the minorities, and that has been taking place as well. And this could very often create the feeling of insecurity among the minorities, and the feeling of insecurity among the minorities would lead to the radicalization of youth, and radicalization would further leads to instances like militancy and even insurgency as well, right? So that could further threaten the national security. So therefore minorities should not be excluded. So a due share has to be provided to the minorities as well. And in fact, exclusion of the minorities has been based on this this is based on a report of a committee, that is Sachar committee, right? So Sachar committee. Now what this Sachar committee has talked about with respect to minorities, particularly about Muslims. So this committee has said that while Muslims constitute 14% of the total population in India, but they comprise only 2.5% of the India's bureaucracy. They just comprise 2.5% of India's bureaucracy, and even their representation in the parliament is also very, very less compared to the proportion of their total population. and this is what is called as marginalization or the exclusion of certain community, and that may create the feeling of insecurity, and that will leads to radicalization, militancy and insurgency. And apart from that, there is also a growing radicalization among certain communities, particularly youth being attracted to the radical ideas or radical groups, particularly the Islamic State of Iraq and Syria that we have seen in the past. And we have seen a number of youth from states like Kerala have joined the IS, right? So therefore it could threaten the secular fabric of this country, right? So these are some threats that could challenge the secular fabric of the Indian society. Now what are the other challenges? The other challenges, communalism is a challenge, right? Because communalism ruptures the harmony, and it could also create a religious discord as well. And vote bank politics is also another major problem, particularly mobilization of people on the religious lines and developmental disparities among the different communities or the religious communities, and even the limited interpretation of the idea of secularism. And apart from that, the defective educational system that has failed to inculcate the moral values and fraternity, brotherhood among different communities. So these things are actually threatening the secular fabric. And normally if you write 5 to 6 points, then that would be enough. And also make sure that you write maximum number of examples for these particular points, so that you could get good marks. And what measures can actually help India become a truly secular state? So there are certain measures that has to be taken to make sure India could become a secular state. Now one thing that we should understand here is that education can be an effective tool to make India a truly secular state, right? So individual examples like sharing and mutual help could actually reduce the prejudices, discrimination and stereotypes and suspicion between the different communities, and that would strengthen the bonds of brotherhood, and that would also result in development of fraternity, the feeling of fraternity among different communities, and that would result in the religious harmony, right? So that would result in religious harmony among the various communities. And in fact, there should be certain social reforms that have to be undertaken, particularly the uniform civil code. And we all knew that recently Uttarakhand state government has implemented uniform civil code, and Directive Principles of State Policy, Article 44 of the Indian Constitution directs state to implement uniform civil code, right? So Uttarakhand is the first Indian state to implement the uniform civil code. So therefore, what is a uniform civil code? So uniform civil code essentially means that diversity of India has been recognized by the Indian Constitution. So because of that particular reason, for different religions, in order to govern their personal matters, there are different laws that are existing. But a uniform civil code means a uniform law that governs the religious or the personal, not religious, the personal matters of people belong to all religious communities, right? So that is known as a uniform civil code. And uniform civil code's primary objective is gender equality. Primary objective is gender equality and prohibition of discrimination that has been existing within various religious communities. So these are some of the objectives of the uniform civil code, right? So therefore, social reforms like uniform civil code will have to be organized, and public opinion should be mobilized on the secular character of the Indian Constitution, and even minorities should also be encouraged to participate in the mainstream of national life, and that is very, very important here. And in fact, move towards a secular politics. For example, we very often see communal politics, right? So communal politics, and apart from communal politics, we also very often see the vote bank politics also. Vote bank politics or a communal politics, so that we very often see. Now it is very important that we should have a healthy democratic culture, healthy democratic culture, so that it would not result in vote bank politics or communal politics. So people will not fall prey to the communal politics and vote bank politics. And it is very important to inculcate a religious tolerance, and it is also very important that these secular politics should be done by the political parties. And in this context, the Representation of People Act should be further tightened, and Election Commission of India should be given more powers, right? Election Commission of India should be given more powers, particularly the code of conduct. So code of conduct should be given the statutory status, and if any political party, if any candidate uses religion, if any candidate try to do the vote bank politics, the candidature of such a candidate should be immediately terminated. So such reforms have to be implemented so that the political parties and the candidates will not use religion for vote bank politics or doing communal politics. And apart from that, it is also very important that we need to act on religious extremism, particularly the religious fundamentalism. Religious fundamentalism is a major challenge that we should act, and the radicalization of the youth as well. So for that matter, we have to provide them employment, we need to provide them more access to education, skill development, entrepreneurship training. So all these things have to be done so that we could actually counter the trend of radicalization among youth belong to certain communities. And we need to provide them more opportunities, and we should also protect the minority communities from violence and hate crimes, and that plays a very, very important role in further strengthening the secular character or the secular fabric of the Indian Constitution. I hope you have understood about this. Now, what the conclusion should be. So what type of a conclusion you should write? So India has come a long way after independence, almost like more than 75 years since India has achieved its independence. And so India is largely been a secular society, I would say, right? So it is largely been a secular society because the state is not promoting one particular religion or one single religion, and in fact there is also a mutual cooperation and mutual respect among the people in this country, except some instances of religious intolerance. So however, steps like social reforms have to be brought in, particularly the uniform civil code. Religious intolerance is also another very important area. Religious brotherhood, fraternity, tolerance. So all these things have to be inculcated among people, so that could help further strengthen, achieve the goal of the constitutional makers. So what is the goal of the constitutional makers? The goal of the constitutional makers is India should be a secular society, right? So India should be a functional and a healthy democracy, and that could be achieved by adopting these measures. Now, next topic we have understood about secularism. Now we'll try to understand some important aspects with respect to fundamental rights from which are mentioned in part 3 of the Indian Constitution from Article 12 to 32. Now understand one thing, fundamental rights is also very, very important topic. And in fact, you could expect at least 1 or 2 questions from the fundamental rights, particularly from Article 19 of the Indian Constitution, as well as Article 21 of the Indian Constitution, or right to religion, Article 25 to 28 of the Indian Constitution, and even right to constitutional remedies, Article 32 of the Indian Constitution, because that has been providing for the judicial review. right? So judicial review. So therefore, in this context, we will understand about these fundamental rights, what are the important judgments of the Supreme Court, so that has actually defined these fundamental rights or shaped these fundamental rights in a very detailed manner. Now whenever you get any question with respect to the fundamental rights, so you could actually write this introduction. Now fundamental rights which are embodied in the part 3 of the Indian Constitution, right? So they are part of the they are embodied or embedded in the part 3 of the Indian Constitution, and in fact these fundamental rights are considered as the cornerstone. They are considered as the cornerstone of the Indian Constitution, or cornerstone of the individual liberties in India, individual liberties and democratic principles and even social justice, because fundamental rights play a very, very important role in shaping an equitable society. So they shape an equitable society, and they could also play a very important role in preventing the authoritarian rule, right? So they prevent the authoritarian rule. Now whenever such a question is being asked, you could write this. So fundamental rights play a very, very important role in creating an equitable society, and they could also prevent the providing equitable the equitable society, and also preventing the authoritarianism by the rule, or authoritarianism by the state, right? So these are the 6 fundamental rights that the Constitution has provided for. I hope all of you knew about these 6 fundamental rights. For example, right to equality from Article 14, Article 18, right? So, and right to freedom, Article 19 to 22, right against exploitation, Article 23, 24, and right to freedom of religion and right to constitutional remedies as well. So we'll understand all these different rights very briefly, and we will also understand what are the important cases that are being associated with these particular fundamental rights. Now, why fundamental rights are very important? So we have understood that fundamental rights are cornerstone of individual liberties, democratic principles, and they are also very important for social justice in any state. But why specifically these fundamental rights are very, very important, and why they are necessary? Now, in fact, Indian Constitution itself talked about the political democracy and fundamental rights. The part 3 of the Indian Constitution will ensure political democracy in India. So political democracy by protecting the rights of individuals, protecting the civil liberties of the individuals, and also instilling or inculcating the democratic principles as well. So therefore it promotes political democracy, and it would also safeguard individual liberties against state intervention as well, right? For example, so right to life and personal liberty is considered as a very important right. So therefore fundamental rights protects right to life and personal liberty. So going into the discussion, we will understand how fundamental rights will safeguard the rights of individuals in a very detailed manner, and this could also foster an all-round development of the individuals and the country as well, right? So apart from that, the fundamental rights also prevent the authoritarian and dictatorial rule, because the fundamental rights are provided to the individuals against the state action, right? So it protects individuals' civil liberties from the state's interference. Okay, so apart from that, fundamental rights also act as a bulwark against the tyranny of the executive and even the arbitrary laws of the legislature. Because one thing that you have to understand here is that Supreme Court or Supreme Court is considered as the custodian of the Indian Constitution. So if your rights are violated, you are an aggrieved citizen and you could directly approach the Supreme Court. But in normal ordinary cases, this is not the matter. There is a hierarchy of courts, so you have to approach the lower court and then the higher court and then the Supreme Court. But if your fundamental rights are violated under Article 32 of the Indian Constitution, you can directly approach the Supreme Court. right? So that's how fundamental rights are given such a major importance that you could directly approach the Supreme Court and ask the Supreme Court to restore your fundamental rights as well, and Supreme Court directs the state to immediately protect or immediately restrain from violating the fundamental rights of an individual. Right, so this is the necessity and importance of the fundamental rights. Now we'll understand the distinctive features of fundamental rights. So what are certain unique features of the fundamental rights that the Indian Constitution has provided for? And in fact, the fundamental rights are available to all citizens in India, right? So in fact, some fundamental rights are available to even foreigners also, citizens and non-citizens also, but mostly these fundamental rights are available to all citizens. For example, right to life and personal liberty under Article 21 of the Indian Constitution, it is available for both citizens as well as the foreigners as well, non-citizens as well, right? So similarly, Article 16 of the Indian Constitution, that is available only for the non-citizens. That is available only for the citizens in India. So Article 14 of the Indian Constitution, that is available for both citizens and the non-citizens as well, right? So therefore, so these are some distinctive features of the fundamental rights, that they are available for all persons, with some rights exclusive to the citizens of this country. And in fact, so the other thing that you need to understand is that fundamental rights are not absolute. So they are not absolute rights, but they are subjected to the reasonable restrictions. Okay, so subjected to reasonable restrictions. For example, Article 19 of the Indian Constitution talks about freedom of speech and expression. So since I have a freedom of speech and expression, I could go to the public and I can speak anything that I wanted. So that's not how things work. There are certain restrictions on your freedom of speech and expression also, right? So public health, morality, public order, so all these things have to be kept in mind, and that is what is called as reasonable restrictions. And since you have right to life and personal liberty, you could go to the public and you can do anything. No. So these are called as reasonable restrictions. One thing that you need to understand, the fundamental rights are not absolute, but they are subjected to reasonable restrictions. So apart from that, fundamental rights also protects you from the authoritarian tendencies. Here I would like to mention some important articles, particularly Article 20 of the Indian Constitution as well as Article 22 of the Indian Constitution, right? So protection in respect of conviction of offenses is what Article 20 talks about, right? So these articles specifically mentions about protection from the authoritarian or arbitrary laws of the government, Article 20 and Article 22 of the Indian Constitution. And in fact, these fundamental rights, a combination of a restrictive as well as positive or privilege conferring character as well. For example, Article 17 talks about the abolition of the untouchability. So you should not practice the untouchability, and that is the restrictive practice, right? So untouchability is unconstitutional and illegal. You should not practice untouchability. However, there are certain positive rights as well. For example, Article 21, right to life and personal liberty, is considered as the positive or privilege conferring fundamental right. Similarly, Part 3 talks about the fundamental rights, particularly from Article 12 to Article 32 of the Indian Constitution, and these are justiciable in nature and they could be defended in the court of law. That means if you believe that any of these fundamental rights are violated, you could approach the courts immediately. So you could even approach the Supreme Court directly, even if you believe that any of your fundamental rights are violated, and that is why
it is said that these fundamental rights are justiciable and they can also be defendable in the court of law. But the other thing that you should understand, the directive principles of state policy which are mentioned in the part 4 of the Indian Constitution, they are not justiciable in nature, right? So if state do not apply the directive principles of state policy while they formulating the laws, you cannot go to the courts and ask the courts to issue a directive to the state to implement the DPSPs. They are non-justiciable in nature, and in fact the fundamental rights also have the direct enforceability with some exceptions, because they are subjected to reasonable restrictions and they are not absolute, and there are also possible restrictions under certain circumstances such as martial law as well, right? So in certain circumstances martial law can also be enforced. For example, Article 34 of the Indian Constitution, Article 32 talks about, Article 33 talks about the limitations on restrictions on the fundamental rights or rights of certain security forces, and Article 34 talks about the martial law. So whenever this martial law has been imposed, some of your rights will not be implemented, or some of your fundamental rights are not enforced. Now we'll understand what these different articles talking about and what are the important judgments of the Supreme Court with respect to these articles. Now Article 12 provides for an expansive definition of the state, right? So Article 12 of the Indian Constitution, you should remember that it has been providing the definition of the state. Now as per Article 12 of the Indian Constitution, the state constitutes the government of India, the parliament, and the government and the legislature of all states, and the local authorities, particularly panchayats and municipal bodies, and other authorities which are statutory and non-statutory in nature, and they comes under the definition of state as per Article 12 of the Indian Constitution. And in fact, what does Article 13 of the Indian Constitution has been talking about, right? So Article 13 declares that all laws that are inconsistent or in derogatory of any of the fundamental rights shall be void. Okay, so for example, any law which has been framed or passed by the state legislature or the parliament, but that particular law is inconsistent with or a derogation of any of the fundamental rights, will be considered as unconstitutional, right? So this is what the Article 13. For example, what if the parliament passes a law and takes away right to life and personal liberty? So in that case, so that particular law is inconsistent with or a derogation of the fundamental right to Article 21, right to life and personal liberty, so that the court will declare that law as unconstitutional, right? So it is void. So therefore, Article 13 of the Indian Constitution expressively provides for the doctrine of judicial review. It expressively provides for the doctrine of the judicial review. And in fact, the Supreme Court under Article 32 and High Courts under Article 226 of the Indian Constitution, so they can also declare any law which could be any law as unconstitutional or invalid on the ground of contravention to any of the fundamental rights, right? So you have to remember Article 32 and Article 226 of the Indian Constitution. And in fact, now the earlier view was that constitutional amendment was not a law, so therefore it cannot be challenged. For example, imagine that a constitutional amendment has been passed by the parliament, and that constitutional amendment is inconsistent with or in derogation of any of these fundamental rights, then it will not be challenged. So that was earlier stance. So that was the earlier interpretation of the Supreme Court, because Supreme Court has held that constitutional amendment is not a law, hence cannot be challenged. But this trend has changed after the Keshwanand Bharati judgment of the Supreme Court in 1973, where it has given the doctrine of the basic structure, right? So in Keshwanand Bharati judgment of 1973, the Supreme Court has held that constitutional amendment also can be challenged on the ground that it violates the fundamental right that forms part of the basic structure of the constitution. Right, so this is what the Supreme Court has held that. Now we'll understand about right to equality from Article 14 and Article 18 of the Indian Constitution. Now right to equality that has been enshrined in these 4 articles of the Indian Constitution, so they could also considered as form a cornerstone of a democratic nation and championing the principle of equality among all citizens and equal treatment of all citizens, and this ensures a rule of law. This ensures a rule of law in the country, because Article 14 of the Indian Constitution forbids discrimination and it endorses equal protection of every citizen of this country under the existing law. Now, so there is a tussle, there is a conflict between equality before law and equal protection of laws. So we'll try to understand this dimension as well. Now, when we talk about the equal protection or equality before law, so an idea of a British origin. So equality before law or rule of law is an idea that is a British origin, and in fact it negates any special privileges in favor of any one single person. So therefore, equality before law actually subjects all individuals to ordinary law, and it also affirms that no person is above law. So everyone equal in the eyes of the law, and that is what equality before law talks about, and it is an idea of British origin. However, the equal protection of laws is also another idea, and that is the American concept, because it calls for equal treatment under the identical circumstances and consistent application of same laws to all persons in the similar situations. Okay, so this is what the equality before law and equal protection of laws have been talking about. However, there are certain exceptions under Article 14 of the Indian Constitution. Now, what are those exceptions? For example, exceptions in the sense that the state or the parliament can provide a special provisions for certain disadvantaged sections. What are those disadvantaged sections here? For example, women, children, socially and economically backward classes, scheduled caste, scheduled tribes, in the public institutions and even the government employment as well. And this has been mentioned in the first constitutional amendment, right? So this has been talked about in the first Constitutional Amendment Act. And the provisions such as there are certain socially, educationally, economically underprivileged or backward classes such as SCs, STs, women, so they could be provided admissions in the educational institutions, including the private ones, except the minority educational institutions, and that was mentioned through 93rd Constitutional Amendment, right? So that has been talked about in the 93rd Constitutional Amendment. And recently through 103rd Constitutional Amendment, 10% of the reservation was provided for the economically weaker sections among the upper caste. So far they are not covered under the bracket of the reservation, right? So these are certain exceptions to Article 14 of the Indian Constitution, right? So this is also known as the positive discrimination or affirmative action of the state. Now, even a parliamentary privileges in the sense that for the sake of being an MP or an MLA, they also enjoy certain privileges and immunities. So it is being mentioned under Article 105 of the Indian Constitution for the MPs of Parliament and Article 194 of the Indian Constitution for MLAs. So they enjoy certain privileges or they enjoy certain immunities, right? So they enjoy certain privileges and immunities. And in fact, Article 361 also talks about the immunities of the president and the governor as well. So these are certain exceptions. You can call them exceptions to Article 14 of the Indian Constitution. So Article 14 talks about what? It talks about equality before law, right? So equal treatment of all. So however, so these are the exceptions to Article 14. That essentially means that in the benefit of socially, educationally, economically backward classes, the state could actually make certain provisions which aimed at the advancement of these socially, economically and educationally backward classes. So this is also called as affirmative action. Affirmative action or the positive discrimination, right? Positive affirmative action or the positive discrimination. Now Article 15 of the Indian Constitution talks about what? So it talks about prohibition of discrimination on certain grounds, right? So state and private individuals, they cannot discriminate on the grounds of religion, race, caste, sex and place of birth. I hope you knew about Article 15 of the Indian Constitution. So that essentially means that you cannot discriminate among the individuals, either the state or even the private individuals also. So however, it has also provided for certain exceptions. So what are the exceptions? So now states started discriminating, or this is also known as the positive discrimination, right? So this is also called as a positive discrimination. That essentially means that a special provision for women and children, SCs, STs and even socially, educationally backward classes of citizens has been provided, right? So we have a reservation policy, so that is part of the affirmative action, and this reservation policy has provided reservation for scheduled caste 15%, scheduled tribes 7.5%, OBCs 27%, and persons with disabilities 3%, and economically weaker sections 10% of the reservation has been given as per the policy of affirmative action, and this is an exception to Article 15 of the Indian Constitution. And in fact, there are some cases which are specifically related to the Article 15 of the Indian Constitution or the reservation policy that has been followed in India. For example, the Champakam Dorai Rajan case of 1951, and in this Champakam Dorai Rajan case of 1951, the reservation policy has been challenged as it violates Article 15 of the Indian Constitution. However, the Supreme Court has upheld the reservation policy that has been given for the advancement of socially and economically, educationally backward classes to correct the historical injustice. And apart from that, even in Indira Sonai judgment of 1992, the Supreme Court has upheld 27% of the reservation given for the other backward classes in employment and education as per the Mandal Commission recommendations. Right, so Mandal Commission has recommended 27% of the reservation for the other backward classes, and Supreme Court in this particular case upheld 27% of the reservation, and Supreme Court has also set 50% limit of reservation. So reservation should not reach the 50%, right? So apart from that, in Yam Nagraj case also it talks about the promotions, reservation in promotions for the scheduled caste and scheduled tribes, and even Jarnail Singh case also deals with the reservation in promotions for scheduled caste and the scheduled tribes. And next, Article 16 of the Indian Constitution. So it talks about equality of opportunity in the public employment, right? So it essentially means that there should be no discrimination or ineligibility of any employment or office under the state on the grounds of religion, race, caste, sex, descent, place of birth or the residence, right? So Article 17 of the Indian Constitution, it talks about the abolition of untouchability. Now, in order to make sure that untouchability is not practiced at the ground level, the Parliament has actually passed two important legislations. One is Protection of Civil Rights Act 1955, and it has also passed the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act of 1989 as well, right? So the main objective of this particular legislation is that prevention of atrocities committed against scheduled caste and scheduled tribes by increased surveillance, right? So these are two legislations that have been passed by the parliament to prevent atrocities committed against the scheduled caste and scheduled tribes, and also protection of their civil rights and civil liberties as well. And apart from that, Article 19 Clause 1, this is a very, very important right which has been mentioned in the Indian Constitution, and this could also be considered as a cornerstone of individual liberties. So this is a cornerstone of individual liberties. Now, what exactly this article has been talking about? So this article has been talking about the freedom of speech and expression. Article 19 Clause 1 ye, so it talks about the freedom of speech and expression. So that means the fundamental right of individuals to articulate one's views, one's opinions, ideas without a fear of retaliation, censorship, and the legal sanction, right? So this is a very, very important right. And the freedom of press, takes its source from this particular article. So secondly, right to assemble peacefully without arms, and this is part of Article 19 Clause 1 and Clause B. So the right to come together and collectively express, promote, pursue, and defend the common interests of the individuals. And Clause C of 19(1) talks about the right to form associations or unions or even cooperative societies, right? So that they could collectively express, promote, pursue, defend the common interest. Now, one thing that you need to understand here, the formation of the cooperative societies is a fundamental right, but formation of the political parties is not a fundamental right. So formation of political parties is not fundamental right, but cooperative societies and the formation is a fundamental right under Article 19 Clause 1 Clause C of the Indian Constitution. And apart from that, right to move freely throughout the territory of India, this is also a fundamental right. However, this right can be restricted in the interest of general public as well as the scheduled tribe population as well. And in fact, the right to reside and settle in any part of the territory of India. So these are, the rights which are provided in Article 19 Clause 1 of the Indian Constitution. And apart from that, right to practice any profession or carry on any occupation, trade or business. This is the another right under Article 19(1) Clause, so these are 6 fundamental rights. Okay, so Article 19 Clause 2 talks about what? So Article 19 Clause 2 talks about there are certain reasonable restrictions. Now, one thing that we need to understand, these rights that we have just discussed, they are not absolute in nature, but they are subjected to reasonable restrictions. And Article 19 Clause 2 talks about the reasonable restrictions that could be imposed on these rights based on the grounds mentioned in the article. However, here we need to understand 2 very important cases. One is the Shreya Singhal case of 2015 and Kedarnath Singh case of 1962. So in Shreya Singhal case of 2015, so this case particularly dealt with the Section 66(a) of the Information Technology Act of 2000. So IT Act of 2000, Section 66(a), so that has imposed punishment for sending grossly offensive or menacing information. Okay, so therefore it has given arbitrary and sweeping powers to the state. Right, so this Shreya Singhal case has given arbitrary and sweeping powers to the state, and Supreme Court has struck down Section 66(a), establishing its ruling as a pivotal movement in online free speech. And in fact, in Kedarnath Singh case of 1962 also, the Supreme Court has upheld the constitutional validity of the sedition law. Right, so Section 124(a) of the Indian Penal Code talks about the sedition law, and Supreme Court has upheld the sedition law in Kedarnath Singh case of 1962, stating that criticism of the government cannot be considered as a sedition unless it incites or calls for a larger violence. Now, Article 20 of the Indian Constitution, and Article 20 is also another very important article, because Article 20, so that actually enshrines the principles of legality, double jeopardy, and the principle of self-incrimination. And the principles of legality, double jeopardy, and self-incrimination serves as a robust defense against the arbitrary punishment by the state. Right? Now, in fact, Article 20 of the Indian Constitution talks about two important aspects. Now, one is, so there should be no ex post facto law. So that essentially means that no person shall be convicted of any offense except for the violation of law in force at the time of the commission of the act. Okay. So secondly, it also talks about, subjected to penalty greater than that prescribed by the law in force at the time of the commission of act. So there should not be a greater penalty for any crime committed by any individual, but the penalty should only be based on the law that is existing at the time of commitment of the crime. Right. So there are two significant cases. One is the Selvi versus State of Karnataka case 2010 and DK Basu versus State of West Bengal case in 1997. So the Selvi versus State of Karnataka case, the Supreme Court has restricted the use of narco-analysis, brain mapping, because this reinforces the protection of self-incrimination. Giving evidence against himself or herself is what is called as the self-incrimination. Secondly, DK Basu versus a State of West Bengal case in 1997, which defined the administration of polygraph and narco tests as cruel, inhuman, degrading treatment by the Supreme Court, so thereby expanding the interpretation of Article 21 of the Indian Constitution. Right? So this includes the forms of treatment. And now a very important article, Article 21 of the Indian Constitution. So that talks about right to life and personal liberty. So Article 21 of the Indian Constitution guarantees the right to life and personal liberty subject to procedure established by law. It's the foundation of a broad range of human rights, including the right to privacy and the right to live with dignity as well. Right. So in this context, Article 21 is governed by different fundamental rights. Article 21 of the Indian Constitution. So there are different judgments of the Supreme Court. So that specifically deals with the Article 21. Firstly, A.K. Gopalan case. So A.K. Gopalan case interpreted the procedure established by law. Now, Indian Constitution has provided for the procedure established by law, but there is no due process of law. Now, what is the procedure established by law? Now, in fact, for example, Article 21 talks about right to life and personal liberty. Now, in fact, the Parliament through a law can take away Article 21, but it cannot be done through the executive action. So it cannot be done through the executive action. So everything is right if it is done through the Parliament, and that is what is called as the procedure established by law. So I hope you have understood this. That is what is called as procedure established by law. So everything, whatever Parliament to do, that is right, and this is what the Supreme Court has talked about in A.K. Gopalan case. A.K. Gopalan case in 1950. So in this particular case, the Supreme Court has interpreted that the procedure established by law was narrowly interpreted by the Supreme Court. The protection under Article 21, the Supreme Court has held that the protection available under Article 21 for right to life and personal liberty is only available against the arbitrary executive action, but not the legislative action. Right? So here you could see that Parliament through a law can take away your right to life and personal liberty, and that is the narrow interpretation of the right to life and personal liberty under Article 21 of the Indian Constitution in A.K. Gopalan case. However, in Menaka Gandhi case of 1978, an important principle of the due process or important concept of due process of law has been, started, by the Supreme Court. Right, so Supreme Court has actually widened the interpretation of the procedure established by law. Now, earlier in A.K. Gopalan case, the Supreme Court has held that the protection under Article 21 is available only for arbitrary executive action, but not for arbitrary legislative action. But in Menaka Gandhi case of 1978, the Supreme Court has broadened the scope of the procedure established by law, and now the Supreme Court has started including the protection to an individual under Article 21 even against the arbitrary legislative action as well. So arbitrary legislative action, not just the executive action, but arbitrary legislative action, and that is what is called as the due process of law. However, in Puttaswamy judgment of 2017, this is considered as a landmark judgment, and in this judgment, the Supreme Court has held that right to privacy is part of the fundamental right under Article 21 of the Indian Constitution, and it is intrinsic to freedom of life and personal liberty. So this is what the Supreme Court has talked about with respect to Article 21 of the Indian Constitution. And in fact, Supreme Court in Navtej Singh Johar case, it has decriminalized homosexuality, and even the Supreme Court has abolished the provisions related to the adultery as well. Right, so those are the provisions which specifically talks about or deals with Article 21 of the Indian Constitution. And even Swapnil Tripathi case in 2018, the Supreme Court has upheld the right to access justice under Article 21 of the Indian Constitution. Right, so even Article 21 also talks about the right to be forgotten, and that is a relatively recent concept. And right to be forgotten actually refers to the ability of individuals to limit, delink, delete, correct the disclosure of personal information on the internet. Right, so this is a relatively new concept in the Indian jurisprudence, and this right to be forgotten has been emphasized by Justice B.N. Sri Krishna Committee on the personal data protection. Right, and apart from that, Article 21A, so it talks about right to education. Right, so it talks about right to education, and 86th Constitutional Amendment Act has been made in the year 2002, and that has included 21A as a fundamental right. So right to free education. Right, so it talks about right to free and compulsory education for all children who are aged 6 to 14 years. And that is being implemented through a legislation called Right of Children Free and Compulsory Education Act of 2009. Similarly, a recent national education policy was also framed in the year 2020, and that has expanded the age bracket for compulsory education to 3 to 18 years. So thereby it has addressed two issues. One is a need for early childhood care and education, and also extending the provisions of education till the higher secondary school. And similarly, Article 22 of the Indian Constitution, so this is a protection against arrest and detention in certain cases. Right, so this also a cornerstone of individual liberty, protection from the authority in the cases of arbitrary arrest and detention of an individual. And in fact, it talks about the right to be informed on the grounds of the arrest. So that also includes being informed about the right to bail, and right to consult and to be defended by a legal practitioner, and right to be produced before a magistrate within the 24 hours. And this actually prevents the undue arbitrary detention of the individual without the judicial oversight. So thereby it ensures a prompt investigation, and also minimizing the potential for the misuse of power. And similarly, the preventive detention is also another provision. This is part of Article 22 of the Indian Constitution. What are the conditions based on which a person can be arrested or detained under the preventive detention? So detention of a person cannot exceed 3 months without an advisory board report. Okay, so it actually prevents the prolonged detention without the adequate justification for the arrest of the individual, and this also curtails the civil liberties of the individual. So if such a prolonged arrest is in place, and in fact there are two other rights which are considered as a very important rights. So they are right against exploitation, which are mentioned in Article 20 to 24. So Article 23, prohibition of traffic in human beings and also forced labor. And human trafficking is one of the major problem. So women are being trafficked for forced labor, sex trafficking, and even organ trafficking. So this article protects individuals from the trafficking, and even this article also protects individuals from the forced labor, which is otherwise called as beggar, right? So it refers to a practice of compelling individuals to work without payment, which is a gross violation of the human rights. And apart from that, the People's Union for Democratic Reforms, a Union of India case, this is one of the very important case in the Supreme Court, and it is considered as a landmark judgment that reinforced the right against the forced labor. And similarly, Article 24 of the Indian Constitution, and this article talks about the child labor, right? So it specifically talks about the child labor, so prohibition of employment of children in the factories. This article prohibits child labor, and child labor is one of the major problem in India, and it is still a major pressing issue in many sectors of the Indian economy. So child labor, the reasons are poverty and lack of education are the major reasons, and this article protects children from the child labor. And we have already discussed about right to freedom of religion from Article 25 to 28, and it reflects the secular character of the Indian Constitution, and it embodies the principles of secularism. And these rights actually allow the individuals and the communities to practice their faith without fear of discrimination, subjected to public order, morality, and health of individuals. Right? So cultural and educational rights, which are mentioned from Article 29 to 30 of the Indian Constitution. Right? So the Constitution, appreciating India's vast cultural diversity, also protects the cultural and educational rights under Article 29 and 30 of the Indian Constitution. So Article 29 talks about the rights of the minorities to protect, conserve their own culture and language, and Article 30 talks about the rights of the minorities to establish and administer educational institutions of their choice. Right? So therefore, no minority group is alienated and marginalized, since they are provided the constitutionally guaranteed protections. However, Article 32 of the Indian Constitution is one of the very important right here that we need to talk about, we need to discuss about. Article 32 of the Indian Constitution, it actually confers the right to remedies for the enforcement of the fundamental rights. Right? For example, if any individual's fundamental rights are violated, the person can approach the Supreme Court directly. And in fact, the Supreme Court has also held that Article 32 of the Indian Constitution is part of the basic structure doctrine, or it is a basic feature of the Indian Constitution. And in fact, Dr. B.R. Ambedkar called Article 32 as a very important provision. And without Article 32, the Constitution would be a nullity. And in fact, it is the very soul of the Constitution and a very heart of it. And this is what Dr. B.R. Ambedkar has said about Article 32 of the Indian Constitution. Right? So this is a right to constitutional remedies, and it also provided certain writs right? For example, habeas corpus, mandamus, and prohibition, certiorari, quo warranto. So these are some of the writs that are available. If any of the fundamental rights are violated, the individual can directly approach the Supreme Court under Article 32 of the Indian Constitution for restoration of their fundamental rights. So recently Supreme Court had said that right to approach Supreme Court under Article 32 is itself a fundamental right. Okay, so in fact